Good morning. Thanks for joining us at Freeths for our nutrient neutrality legal update. When we set this up, little did we know there'd be quite so much to talk about. So yeah, it's a timely event. Thanks all for joining. I'm going to kick off with a little bit of an introduction, and then Richard Broadbent, who you can see on the screen, is going to speak for 20-25 minutes or so, and then I'll come in at the end. So just before we talk about nutrients, it's obviously important that we tell you all about Freeths. So Freeths Planning and Environment team is a significant team now. We operate from 6 different offices. Here's the senior members of the team. There are 8 of us. We have planning consultants, planning lawyers, and environmental lawyers. Richard and I are environmental lawyers, but we cover all planning and environment issues. Next slide, please, Richard. And yeah, I think I've just said all that. Oh, the other thing I should say is that we have advocates. So Alison Ogley, who works with us, one of those people that we just saw a photograph of, she's actually a planning advocate and takes matters to the High Court and planning inquiries. So yeah, I think we're going to now start talking about what we're actually here to talk about. So nutrients. So we're going to give you a bit of background to start with. Then we'll talk about the famous Fry case. And we're lucky enough to have one of G Fry's people on the call with us. Then we're going to talk about, of course, the Levelling Up and Regeneration Bill and the original amendments, and then the most recent amendments, which have been publicised widely. And then we'll talk about what does this mean for developers. So over to Richard. Thank you.
Great. Good morning, everyone. I'll start off with some background, tell you the story of how we got here, cover the Fry case, and then we'll talk about the LEB amendments and what that means for developers. So a bit of background then. This is what excessive nutrients in river systems looks like. So in freshwater habitats and estuaries, increased levels of nutrients, especially nitrogen and phosphorus, can speed up the growth of certain plants, and that disrupts natural processes and impacts those wildlife sites. So on the right here, you can see a stream that should be clear. It's not, it's full of algal blooms. And here is an estuary too, and it's matted with algal growth because of excessive nutrients, and that affects the ability of that ecosystem to function, provide a food source for birds, and so on. So that this is what excessive nutrients are doing, and it's causing a favorable condition to these sites. And in fact, a House of Lords report from July this year said that nitrogen deposition is the most significant and widespread pollutant, leading to habitat changes and impacting on habitats and species across England. And that 89% of sites of special scientific interest across the country are predicted to exceed their critical nitrogen thresholds, which will impact their conservation objectives. So this is the real pollution problem that we're dealing with. And this has become a legal interest as a result of the Dutch nitrogen cases back from 2017, 2018, which are at the application of the Habitats Directive in the Netherlands. And the CJE ruled, the Court of Justice of the European Union ruled in those Dutch nitrogen cases, that the government's approach to nitrogen emissions, this is from air emissions primarily, and its impact on European sites was inadequate and violated the Habitats Directive. They held that the Netherlands failed to properly assess and mitigate the harmful effects of nitrogen emissions on European sites. And in coming to that conclusion, what the Court of Justice of the European Union said is that where the conservation status of natural habitats is unfavorable, so where they're in unfavorable condition, a declining condition, then the possibility of authorizing activity which may subsequently affect the ecological status of the site's concerns seems necessarily limited. So they're saying that permitting things which will add to that problem is going to be a problem. And as you can see here on the slide, it talks about mitigation measures having to be certain there'll be no adverse effect on the integrity. And the court was saying, conservation measures, preventative measures, other measures, which are not certain at the time of an appropriate assessment of impacts on the European site, well, you can't rely on them. You have to have that certainty. So that created this very difficult situation in the Netherlands and other countries. And in the Netherlands, you can see here a few examples of what's happened as a result of this, and that's that the Dutch government has had to clamp down on emissions, both greenhouse gas emissions, but also nitrogen emissions from agriculture. And if you don't already know, the Netherlands is the world's second largest food exporter by value, behind the US. Agriculture consists 10% of their GDP, and the reductions necessary would lead to 50% reductions in nitrogen and ammonia by 2030, and 75% reductions in the vicinity of European sites. These are SACs and SPAs. And that would mean, for example, reducing cattle in the country by 30%. That means culling, 1 million cows, 4 million pigs, a major disruption to farming. And that led to a series of protests across the country, first of all in 2018 and 2019, and then it stopped through COVID, and then flared up again last year. It led to political upheavals. A new political party formed around this, which did very well in local elections in the Netherlands in the spring. So having major repercussions in that country. And we have that problem here. For us, this manifests itself in two ways, really. Diffuse water pollution is the key one. So that's where nutrients are getting into the water system, into rivers and estuaries. And the other one too, come to light recently, is water neutrality. So that's where you have too much abstraction on groundwater that takes away water from protected sites, and that causes a problem. So to the extent that development is adding to these nutrient loads, or in the case of sites like the Aran Valley, where there's too much abstraction from groundwater affecting European sites, then that needs to be addressed, and addressed through a policy called nutrient neutrality. This map here, published by Natural England last year, shows you the areas in the country which are affected by diffuse water pollution. For a number of years, we were dealing with the issue in the Solent. That's why they're more advanced in other areas in terms of trying to come up with solutions to address this. But last year, Natural England published its advice on this, and which showed that it affected other areas too, particularly in the northwest and northeast. But also in North Norfolk, for example, in Cornwall. So there are many areas of the country which are affected by this problem. So Natural England's nutrient neutrality advice essentially is that they've advised local planning authorities that housing development in those areas shown on that map need to be nutrient neutral. So that means that development must not add to the existing nutrient burdens on protected sites in those areas. And you figure that out by carrying out a nutrient budget calculation for your development. And that will tell you whether, and if so, how much you need to neutralize the impact, so that what you're putting into the system is neutralized by taking something else out of the system. And that allows you to consume your own smoke, wash your own face, whatever phrase you want to use there. That concept of nutrient neutrality took a while to develop. I remember working with colleagues on it at Natural England, and almost immediately it was challenged in litigation referenced here, Wyatt and Ferrum Borough Council, which Natural England took part in. And in the High Court and in the Court of Appeal, the court found that the nutrient neutrality concept was lawful. So we had a lawful basis on which to proceed with this concept. Importantly, this was only ever going to be a sticking plaster for a problem. Nutrient neutrality is not a long-term solution for the problem of diffuse water pollution. And so the government planned other things to address this. One of them, announced last July, was that they would provide a new legal duty on water sewage companies in England to upgrade their wastewater treatment works by 2030 in nutrient neutrality areas. And they would do that to the highest achievable technological levels. And what they were trying to do there is go, okay, well, if the impact from development is felt through wastewater, and that goes through mostly through to wastewater treatment works. Well, let's target those. Let's make sure that their performance is better, and we'll focus on the upgrade of that. And that's where these standards were introduced. So specific standards for phosphorus, for nitrates, and the idea was that by compelling water companies to meet those levels, you would need less mitigation for your development over the lifetime of your development. So that was another way of trying to address this. And you'll have seen in the press, there's been a lot of news about pollution in rivers over the last couple of years, a lot of reporting on that. I've just clipped an article here from the Times, claiming that this investment in upgrading water treatment is a victory for the campaign that they've been running on this. It's very much in the public eye, pollution in rivers. In addition to that, Natural England also announced work that they are doing to try and deliver a nutrient mitigation scheme in parts of the country which they have just announced that there are problems and there is no existing market for nutrient neutrality solutions. So rather than leave them with nothing, some attempt has been made. And in this case, in the Tees catchment, for example, up in the northeast, investing 30 million in a new scheme for nutrient mitigation to try and ensure that there are opportunities available to developers to purchase nutrient credits so that they can neutralize their impacts. But as you can imagine, there aren't a great deal of, there have been real supply issues around the availability of nutrient neutrality solutions, both provided by the market, but also through schemes such as this. But this is where the attempts being made to address this. That leads us neatly on to the Fry case. And if the proposed amendments to LURB are passed into law, which we'll talk about later on, then perhaps we'll see the Fry case as the high watermark of nutrient neutrality in action. So what you have in this case is in 2015, outline planning permission was given for a development. In 2020, reserve matters approval was given, subject to conditions. And then in 2020, Natural England published advice regarding the risk of impact on the Somerset Levels and Moors Ramsar site. So if you're not aware, you have European sites protected under the Habitats Directive, but also under another international convention, the Ramsar Convention on Wetlands. There are Ramsar sites designated across the country. And as a matter of national planning policy through the NPPF, we give those Ramsars the same legal protection as European sites so that we can comply with our obligations under the Ramsar Convention. And so they were saying, okay, well, this site is also vulnerable to excessive nutrient impacts. And therefore, on the back of that, the council refused to discharge the pre-commencement conditions. So, outline reserve conditions. They refused to do that and maintained that an HRA was needed before those conditions could be discharged. That decision by the council was appealed by G Fry, and the planning inspectorate on appeal upheld that decision. And so then that decision was subject to judicial review. And interestingly, the Home Builders Federation joined in that litigation. And there's a little quote here from them in their submissions in that hearing, where they said that diffuse water pollution is delaying an estimated 120,000 homes across 27 catchments currently affected in England, with some 40% having already secured, as in this case, outline or full planning permission, which constitutes, I think, a quarter of the annual housing supply. Development which has planning permission, which has been held up by this. And they also said that nutrient neutrality solutions are extremely sparse on the ground. So the grounds of challenge essentially were that that no HRA was required, contrary to what the council concluded, the PINS inspector and so on. That wasn't required for the discharge of conditions. And as it wasn't required for the discharge of conditions, therefore no nutrient neutrality was required. Interestingly, at the same time as this was going on, in July last year, there was a DEFRA ministerial statement. And in that ministerial statement, they said, we're aware that there is controversy over this. but be aware that HRA provisions apply to any consent, permission, or other authorization. This may include post-permission approvals, reserve matters, or discharge of conditions. So they were, setting out their position on this. And then when this went to the High Court, Sir Ross Cranston, the judge, dismissed the judicial review, and he said that he accepted that on a strict reading of the habitats regulations, the assessment provisions of Regulation 63, that's the assessment provisions, the HRA provisions, they do not cover the discharge of conditions. And if you read them, they don't. They specifically don't cover that. So acknowledged that point that that CG Fry was making in their submissions. However, the court concluded that the regime does apply, and that's because of the continued direct effect of Article 6.3 of the Habitats Directive. So even though we've left the European Union, if there were certain provisions, rights, recognized in our legal system before Brexit derived from directives, then under Section 4 of the Withdrawal Act, you could still rely on those. And Penny relied on that provision in her case, Harris, last year against the Environment Agency, and won it on that basis. So there's a continued direct effect of the Habitats Directive. And then there's a purposive interpretation of the Habitats regulations in light of the precautionary principle, which compels a requirement to make sure that you consider impacts before you allow them to take place. And then there's also case law, which suggests this too. So with all that in mind, the court said, no, it's right to apply HRA to the discharge of conditions. Given the national interest in this, given the impact it's had on house building, CG Fry applied to the Supreme Court to be heard, leapfrogging the Court of Appeal. Recently, that was refused, and we'll see what happens if there's a possible appeal to the Court of Appeal on these arguments. So that was the position up until this summer. Let's catch up on what's happening in terms of the Levelling Up and Regeneration Bill and the new proposed amendments with respect to that. So the announcements were made in July 2022 for water treatment undertakers to up their game to meet these new standards. And then there was a period of sustained political chaos in this country. And so the amendments weren't made to LUB until December of last year. And when those amendments were made, what they said is that there would be new requirements on sewage disposal works to meet those nitrate and phosphate standards by 2030. So there'll be time given for them to meet those standards. And then amendments made to the habitats regulations that said that from 2030, you could assume that those standards have been met, and therefore assume that when you're making your planning decisions and carrying out habitats regulations assessments. So there was a sort of, a period of getting your house in order, and then this would kick in, and then you could assume there wasn't an issue. If those standards hadn't been met for whatever reason, then the Secretary of State could make a direction saying they hadn't been met, and therefore you could discount that assumption at that stage. So that was what we were thinking would be passed into law. But this growing issue of, as the Home Builders Federation said here, nutrient neutrality holding up 140,000 homes, move into this year, we have a housing crisis already. That then turned into a mortgage crisis with interest rates being hiked up. And then that turned into a renters crisis. And people in this country, can't buy homes. It's having huge impacts societally. And so that has to be, addressed. And so we were hearing through the sort of summer period that that something more would be done to address this. And an article in the Times saying that Rishi Sunak was minded to support a move by Gove to change the law to allow development to go ahead in advance of those upgrades being made in 2030. And Michael Gove saying that the nutrient neutrality rules should be changed because they get the balance wrong. And here's just a sample of the articles which came out over the summer over this, clearly building up towards something. It just wasn't particularly clear what that was. A back and forth with Natural England over this, various announcements. And then last week, we got the announcements about further amendments to LURB, the Levelling Up and Regeneration Bill, to address this. And an announcement made by Delic last week, they said that the government announces the plan that they will unblock house building to deliver homes for local communities whilst also protecting the environment. And they would amend the bill to do away with the red tape around this and allow house building to go ahead earlier. And they also said that would include significantly expanding the investment in and involving, for example, the nutrient mitigation scheme. And what that meant was there wouldn't be a need for nutrient neutrality solutions anymore if those amendments became law. Hence the need to evolve their nutrient mitigation scheme into something else. So that was the announcement that we received just last week. And then later in the evening, the amendments were published. And Baroness Scotta Bybrook's picture over there, publishing those and in the House of Lords. And there's a link here to the full amendments. There's pages of them. And as you can see from this little clip here of the progression of the bill, this is happening very much at the end of this process. It has gone through its bill passage through the House of Commons. It is going through it in the House of Lords almost at the end, and now quite a substantive amendment is being made, which I believe is being debated today in the House of Lords, next week in the House of Commons. So significant changes very much at the 11th hour around this. And what do those proposed LURB amendments say? Well, they remove in England the need for planning decision makers to consider nutrient pollution from urban wastewater in HRAs, taking that out of the equation. And they do this by instructing planning decision makers to assume that nutrients in urban wastewater will not adversely affect European sites. So you make that assumption now, not in 2030 when the upgrades happen, but now. And you do that even if findings in the appropriate assessment conclude that there will or could be nutrient-based adverse effects on protected sites, and even where there is advice from Natural England or any other person regarding those potential adverse effects. So even knowing that by permitting something now that will lead to harm, you turn a blind eye to that and assume that this will be dealt with because of other things being done by the government to address nutrient pollution. And then in addition to that, you have the specified nutrient water quality standards that we heard about from July last year, were put into the amendments in December last year, but souped up in ways so that they could be ratcheted up or ratcheted down regarding water quality standards to be met, and further provisions around how that's going to be achieved. And what this really does is shifts the problem of nutrient neutrality from the planning sphere and planning decision making and pushes it into the sphere of environmental permitting, water treatment. It's onto the water companies now. It's onto the Environment Agency as their regulator. That's what's happening here. Now, these are just proposed amendments. They have to be debated and passed into law, and then they have to come into effect once they, the Levelling Up a Generation Bill receives royal assent. And so a letter was sent out to the Chief Planner last Friday, which is worth having a read, and there's a link to it there. And in that, it says that until the provisions come into effect, it's important the planning decision-making continues, and decisions will need to be taken on the basis of the current legal framework. So status quo applies until this happens. And that the proposed changes to HRA would only apply in areas affected by nutrient neutrality. This does not change the position, for example, for water neutrality in places like the Arun Valley where that's an issue. Almost immediately, the Office for Environmental Protection, this is the new body created post-Brexit to take on the role of the European Commission as the sort of watchdog for environmental law in this country. It wrote a letter to DEFRA saying the proposed changes would demonstrably reduce the level of environmental protection provided for in existing environmental law, and that it is a regression in environmental law. And Teresa Kofi here, Secretary of State for DEFRA, wrote back saying, no, I don't accept that. It will not lead to a regression. It is the government's judgment that it will not because of the reform package that they are proposing. But there is an argument, as you can see, between the Office for Environmental Protection and government over whether this actually constitutes a regression. Great. I'll hand over to you now, Penny, to talk about what this means for
Okay, thank
developers.
you. And please do put any questions in the Q&A if you want to, as we're talking, particularly during this session. If you're a developer, you may have questions, or other people. So, okay, next slide, please, Richard. So basically, obviously, this is good news for house builders and other developers if the laws go ahead. There's no change yet, obviously, we know that from the letter that was written by the chief planner, and that's obvious anyway, that the amendments are only proposed at the moment, so we don't have any change yet, and so that's something to be very aware of. It's business as usual at the moment, but you know, if these amendments do get adopted, then there is going to be a benefit for house builders, no doubt, and other people who are building developments with wastewater impacts. You know, we're pretty certain, well, it's clear already that the House of Lords is going to lobby to fight these amendments, and I'm going to come on in a minute to talk a little bit about the kinds of counter amendments that we're seeing coming forward. And that's because many people do believe, like the OEP, that this does amount to a regression in environmental standards. In terms of proposed amendments, we don't know when they would come into force, if they did come into force. And I think, though, and Richard agrees, that this would probably be at around the beginning of next year. The reason we say that is that I'm sorry, I don't know if anyone else can hear my phone going, but it's really annoying. Anyway, the point is that the rule bill, which is an act now already, says that from the start of January 2024, there will be a change in the way that European law affects us. Up until at present and up until the end of this year, European law remains effectively binding on us, particularly the Habitats Directive, which has been held to be the case in a case we were involved in, like Richard mentioned, the Harris case last September. And it was a case that was highly in the minds of the judges when G Fry went to court as well. So at the moment, the Habitats Directive has direct effect. What that means is you can go to court and you can say, we don't care what the legislation says in this country or what the politicians are saying, the Habitats Directive still rules, and we can rely on that to get a protection for the environment. But come the start of January, that will no longer be the case because of changes that the Rule Act will make. So we think that it would be expected that if these amendments in the LURB bill go through, to remove the need for planning authorities to consider urban wastewater nutrients when they're considering their habitat regulation assessments of development, then we think that would happen from 2020, start of 2024. Yeah, as Richard, I think, mentioned earlier, this isn't going to affect water neutrality or indeed any other aspect of habitat regulations assessment that developers are commonly needing to consider. So, I mean, if you're a housing developer, you quite often have to think about recreational impacts on European sites. You might have to think about air quality impacts on European sites and water neutrality impacts potentially, certainly down in Sussex. But none of that will change. There will still be a need for developers to consider whether other pathways of impact occur from their developments onto European sites. And if there is that prospect, there will need to be a shadow habitat regulations assessment written by, well, normally the developers instruct their consultant ecologists to write that. Certainly the local authorities will need to carry out that habitat regulation assessment. There's nothing to say that these other aspects of HRA will be removed or become redundant. They won't.
Penny, there's a question from someone in the group here saying, how will the House of Lords fight this, given that the AMP7 wastewater treatment works improvements and then the 2030 improvements far outweigh the amount of phosphates new house building puts into the system?
Yeah.
Call me naive, but it seems to be straightforward to me.
Well, I mean, the point is that yes, I mean, I think everyone agrees that in terms of the overall problems for European sites, house builders aren't the main problem. They're certainly not. But I suppose, you know, there is still an element of the problem that is coming from that source, and that will be the basis on which the House of Lords will be lobbying for not having those amendments that have been proposed accepted. And you know, 2030 is some time away. We're having the prospect now of the LURB amendments that have been proposed by the government coming into place, as I say, probably the beginning of 2024. And that's, you know, that gives us 6 years where there seems to be an element of the problem that we were fixing no longer being fixed. So that seems to be, you know, an issue. And I think that's why the OEP have talked about regression.
Yeah.
You know, yeah.
There's a couple more questions, but I'll let you carry on.
Okay, thank you. Okay, so I mean, in terms of what it really means for developers, though, some of the devil is in the detail, and we've been having some really interesting discussions this week with one particular contact of mine, Rob Cunningham, who works for the Nature Conservancy Council. And one thing we've been talking to him about is the fact that urban wastewater derived nutrients is what these amendments focus on. So that means it's the nutrients that come from urban wastewater, which is it's those nutrients that releases the local authority from having to consider this issue in their HRAs. But you know, nutrients don't just come from wastewater; they come from surface water. And although we went to check the definition of nutrient of urban wastewater, and although urban wastewater, it covers well, it means domestic wastewater or the mixture of domestic wastewater with other things, including runoff rainwater. Although that's the case, I understand that in modern houses, it's simply not the case that your surface water runoff goes into the drain and ends up at a sewer. It goes instead to the surface water drains that end up going into controlled waters. So the point is that surface water is not covered by these amendments, which means we have to think about, okay, are there nutrients coming off land into the surface water system, and therefore would they still need to be considered? So the next slide, please, Richard. So so this slide's come from my contact at the Nature Conservancy, and so if you look at the picture on the right, you see that for phosphorus in particular, there is a bit of a problem, because phosphorus levels coming off a field, and this was a field in Norfolk that's been chosen as an example, but the problem is a nationwide problem. That phosphorus is actually less coming off with agriculture than it would be with houses. So there'd be a significant increase of phosphorus coming off houses on the same plot of land if houses were built on that piece of land. And when you look at the Natural England calculator, budget calculator, and I'm looking now at the green box on the left, you know, what's clear is that the calculator does require consideration of the surface water drainage impact. So when you're doing it, if you're one of these ecologists who's looking at that calculator, you'll be asked to put in some information about the surface water. And so the conclusion is that actually, if you are a developer and you've got phosphorus sensitive areas in your area and you're building on a greenfield site, phosphorus may be a problem that isn't covered off by the proposed amendments. So I mean, I would hope that if these amendments go through, that this would be closed out, this problem somehow. But it's something to be aware of. And when our clients are asking us in the last few days, you know, what do we do? You know, can we just forget about nutrients now? And I'm thinking, well, I'm not sure. This is an issue. This particular slide is an issue that is worrying me. You know, many of our clients are dealing in areas where they've had to buy where they're having to look at phosphate and for phosphorus and nitrate credits. And this problem that phosphorus may be an issue and may not be covered off by the amendments, means that there's a sort of residual concern that developers may still have to create a nutrient budget for that issue and may still have to then pay to mitigate it. The other issue is really about SSSIs. So many of you will know that European sites, which is what triggers the need for a habitat regulations assessment, in England and in Scotland and Wales actually, but in England anyway, European sites are always underpinned by an SSSI, Site of Special Scientific Interest. So what that is, it's a designation under the Wildlife and Countryside Act that is sort of our own national designation. There are many sites which are SSSIs which are not European sites, but all European sites are SSSIs. And so the other thing that worries us a little bit is well, if we're going to have all these amendments in the LURB bill about what you do for habitat regulations assessment, which only looks at European and Ramsar sites, what are we saying about the SSSIs? Because many local authorities who've got these sensitive areas within their local authority areas are going to be concerned about the SSSI designation. And so without the government sort of deciding what they're going to do about SSSIs, this doesn't really necessarily get us home and dry as far as the developers are concerned. So this is the wording in the NPPF that protects SSSIs. And interestingly enough, we went to check because the NPPF was reissued yesterday, a new version of it. And we half expected to go in to find something in paragraph 180 that reflected for SSSIs the position that's being adopted or being proposed anyway under the LURB bill. Perhaps it would be a little bit premature to put it into the NPPF yet, but in the end, there's nothing in there at the moment. When it comes to these LURB amendments, if they're adopted, I think the government's going to have to close out this issue for SSSIs as well. Otherwise, I think we're going to be in a right mess. So what have I said here? Yeah, I've said this already, really. There's no announcement about the SSSIs, but yeah. There's one other thing I did want to say as well, which I haven't done a slide for just before I get onto this slide, which is that there is a bit of a gap as well in that, although, as Richard has said, the LURB bill, sets particular, objectives in terms of milligrams per litre for nutrients, for nitrates and phosphates for water companies by 2030. I think it's 10 milligrams per litre for nitrates and 2.5 for phosphates. I think that's right. But anyway, they're set out in the legislation. Those standards are what's technically possible. It's not standards that will necessarily get protection for the European sites. The European sites may well be still being harmed with those low levels. The low levels have been set because that's what's technically possible for the water companies to achieve, not because those levels will protect European sites. And so the question is, when the Environment Agency grants a permit to the water companies to allow them to discharge from their wastewater treatment plant into a controlled water, surely they still have to do an HRA on that permit, and that is something that hasn't been addressed in the LURB amendments. So as it stands, the LURB amendments seem to suggest that the current duty on the Environment Agency to do a habitat regulation assessment on the water companies, when the water companies need permits from their wastewater treatment plants, that requirement does not appear to have been addressed or disapplied. So we're just concerned that this may become a problem for the water companies. What happens if a water company is meeting the standards in 2030, but there's evidence that those standards will not protect the European site or an SSSI? How do we deal with that? So that's another concern. But getting back to the developers and the slide that's in front of us, what do you do if you're a developer and you've got a planning application and you're hearing all this stuff in the news and you're thinking, great, I think we can relax now. Is it right? Well, the first thing to say is it's not possible yet to relax because currently the law hasn't changed, and it I suppose there's a chance it might not change. We don't know. So you can't completely relax yet. There's also, as I say, the 2 points I've just made about SSSIs and phosphorus. But leaving that aside, if you haven't yet submitted an application and you've got one that you want to submit, then ideally you would delay just to find out what's happening on this. Now, that might need you to delay quite a few months, so it may be commercially impossible. And also, remember, we've put this in brackets, remember that mandatory biodiversity net gain kicks in from November at the moment. That's what they're saying. Now, applications made after November will become subject to that 10% mandatory biodiversity net gain. So you may be a developer who wants to actually get your application in before November just to avoid that. That will depend on what your biodiversity net gain planning policies in your local area are. But you know, so it's not easy just to delay, is it? Commercially, it's not easy, and there may be other reasons such as the mandatory BNG. So otherwise, you could submit the application without your shadow HRA and nutrient budget just for the moment and say, well, I'll provide that later. You know, hoping that by the time hoping that by, you know, in due course you'll find out what the actual law is doing, and then maybe you could just not worry about it, save some money on consultants' fees. But then the problem with that is that the planning application may not be validated. I mean, it depends on the local authority, really. It's not a national issue for validation, but there could be local requirements that may prevent that. So that's an issue. The other thing you can do is press ahead with the application, provide the shadow HRA and the nutrient budget, and then try and seek some comfort, have a discussion with the local authority and try and agree with them that in terms of the 106 that you're likely to have to enter into, to say that you will provide evidence of purchasing nutrient credits before you commence development, which is what we normally see. In that section 106, you could perhaps formulate wording or get your lawyers to formulate wording to say this would only be required if the law does not change before you start development. So that would be a possible way forward, and something we're thinking about with our clients. A planning condition to sort of caveat it out might be more tricky because planning conditions have to be sort of certain and reasonable, and there may be a resistance. We think there would be a possible resistance from the local authorities on that. So maybe the section 106 is the way to get that sort of in for yourselves. For planning applications already submitted, there's not much you can do because it's sort of slightly out of your hands in terms of when it's going to get determined. But you could, again, perhaps seek comfort through wording in a section 106 in the way I've just described. I can see there's lots of questions, Richard. Are there other things we should be talking about? Yeah, or not? Or should we carry on?
Yeah, let's finish up and then we can jump straight into questions.
Okay. So before we just finish off then, we just thought we'd talk about what we're hearing is going on in terms of counter amendments in the LUR bill. There's a couple of different ideas that people have had, which might be palatable. I mean, I have to say at the start, both of these ideas are not ideas that would have the same beneficial effect on developers, because the LUR amendments that have been proposed basically remove the problem from developers entirely, subject to the points I've made today. But these other suggested approaches, they don't. They just try and ease the situation for developers rather than actually remove it. So the one suggestion that's come about, we talked about this in one of our blogs, is that, you know, habitat regulation assessment do have that regime does have an existing derogation approach built into it. So if you worry that your plan or project will risk an adverse effect on integrity of a European site, you can still potentially get your consent, so that would include your planning permission, if 3 derogation tests are met. Now, they are quite challenging tests to meet, but if government really put their mind to it, they could write guidance based on the fact that we have a massive overriding need for house building in this country, and that is a national need, and it's from all over the country. So it wouldn't be difficult, we don't think, for there to be a kind of case written to meet those 2 tests, the EROPI, which is the imperative reasons of overriding public interest test, and the no alternative solution test. Those are the two of the three legal tests in the derogation system under the habitats regulations. We think the government could do that. And then, yes, the compensation test, which is that if you're going to do something which might harm a European site, you have to compensate for it. Well, the compensation requirement could also be done strategically, potentially, in a coordinated way. And, you know, it wouldn't necessarily be something that developers would have to have sorted at the time they build. There could potentially be a delay on the compensation because the case law and the position on compensation is slightly more relaxed than mitigation. So, you know, this is one way forward. It wouldn't necessarily remove entirely, well, it wouldn't remove entirely the burden on developers because there's still the compensation requirement, and inevitably they'd have to pay something towards that compensation. But the position could be massively eased if the government took a strategic approach to this derogation test. That's one idea. The other idea we've seen come forward, and I think this is being put to the House of Lords, is that, again, we remove the proposed amendments from LURB that have been put forward. So we keep, in other words, the need for local authorities to consider urban wastewater treatment, nutrients considered within house builders' HRAs. But the government effectively eases the supply of nutrient credits, because one of the big problems is just there aren't enough credits to even buy, let alone
and that pushes up the price of them and adds the cost that developers are facing.
It's you know, the supply is a massive problem at the moment, and so this idea is to create a kind of nutrient credit, government-backed credit, which they could supply, a bit like the BNG credits. So if you know about mandatory biodiversity net gain, there is a system built into that regime where the government is going to offer biodiversity credits to those who can't manage to meet their biodiversity net gain requirements sort of through their own schemes. And the idea behind this potential amendment is for the government to provide a sort of nutrient credit system. So house builders would buy the credits, their responsibility would end there, and it's then up to the government to use that money to basically deliver mitigation. So that's the suggestion there. Okay, well, I think we've looked at all the options. So over to questions, Richard.
All right. So the next question is, the reference to early next year, this is when the low amendments will kick in. Is this to say that nutrient neutrality will not be required, in your opinion, from January or February next year? It's one of the questions that we have. Again, that really depends on when it gets royal assent, and also when the secondary legislation comes out through it. But I know that there is a sort of political imperative here to get this as soon as possible. I mean, that's what the announcement last week said.
We just don't know. I mean, all we can say is that the earliest we think it would be legally feasible to do it would be the start of January, because of the fact that the Rule Act will, at that point, you know, mean that the direct effect of the Habitats Directive will no longer be in place. Yeah.
The next question we have here is, do you think this move will undermine biodiversity net gain? I ask in relation to government previously having said that biodiversity net gain and nutrient neutrality credits could be stacked. But with this potentially falling away, are biodiversity net gain credits less appealing for investors who may instead choose to create carbon credits, which government has said cannot be stacked with biodiversity net gain? It's a really interesting question there. I mean, as far as we know, all the indications are suggesting that biodiversity net gain is going ahead. There will be a market for that, absolutely. And it is sensible, given how land hungry these measures are, that you stack these things. They were looking at nutrient neutrality in the first instance because of the crisis around that. But at a conference that Penny and I attended back in the spring, DEFRA officials there were saying they haven't closed their mind to looking at stacking in other areas. They just focus on nutrient neutrality in the first instance. But I think they need to come up with guidance on that, how that would work. So I wouldn't rule out. I mean, stacking as a concept is out there, and I know there's people who don't like it as an idea.
Yeah.
But for the natural capital market in general to mature, I think stacking is going to be part of that, and biodiversity can be stacked with other things.
And I mean, the rules about what can and can't be stacked are not sort of set out in legislation. That they're just it's set out in gov.uk guidance, or in the case of the Woodland Carbon Code, it's set out within their own rules. They don't want additionality; they want additionality as well, which is what causes a problem for stacking. So I think you know, given that the government did say that nutrients could be stacked with BNG, they could easily turn around and say, if they could do a deal with the carbon people, that they could be stacked as well. Although, of course, you know, planting trees at the density required for the Woodland Carbon Code may not be exactly what you want for BNG. So it may be a more difficult ecological match. I don't know.
Yeah. There's a question here about what about triple SIs, and I think you've already addressed that. Penny, so yeah, absolutely, that is a concern here for the reasons that Penny has just been talking about. Question here, can you explain the difference between foul drainage that goes to wastewater treatment works and urban wastewater? What are the differences between those two things?
Well, I don't think either of us are a particular expert on exactly how the plumbing works. I'm really deferring to the conversations I've had this week with my old contact, who was explaining to me that, you know, the point is that new builds don't discharge surface water into wastewater treatment plants. They don't, in general. So older houses might, but new builds don't tend to. So that was what was underpinning my concern earlier about the fact that surface water drainage that goes directly to controlled waters may not be caught by the LURB amendments.
Yeah. And then there's another question here about urban wastewater and surface water discharge. I think we talked about that. And then, oh, Rob, you're on the call. That's excellent. Rob, you've said on the point about phosphorus and the 2030 deadline going to TAL, and that's the technically available limit. That's the acronym for that. May reduce emissions by more than new house building. But this doesn't mean the site will be reaching its water quality target because other sources remain unabated. In those areas, my understanding is that nutrient neutrality rules would still apply post 2030. So yeah, thank you, Robin. We've been shamelessly ripping off your work here on our slides. So thank you for that clarity there. Steve, OEP's point is that environmental protection will be undermined, whereas the Secretary of State is arguing that outcomes won't be affected on the assumption that sewage treatment will outweigh impacts. Is there precedent for reducing protection based on some promised enhancements that might happen, that might happen in the future? Well, I mean, that's this goes to the nub of the issues talked about in the Dutch nitrogen case, and that's why I was talking about the standard there about being certain that mitigation is going to operate. And what the CJU was saying was, when you're looking at your appropriate assessment and you're trying to assess what the impacts are, the adverse effects are on European sites, you've got to be certain that the mitigation that you're relying on is going to work. You can't rely on uncertain things in the future kicking in. And for that reason, the Dutch government had a problem with what they were proposing in their instance, and that's why they've cracked down with very clear, you know, they're buying up farms, you know, they are, you know, legal provisions to address this. So that reliance on uncertain mitigation in the future is something which goes against the grain of the case law that's developed around the Habitats Regulation, Habitats Directive, and that's the issue here. And then the other thing too is that this pushes the cart and horses through the idea of precautionary principle, which runs throughout the Habitats Directive and regulations, which is ensuring that your activities do not impact upon protected sites, being precautionary about that. Well, here you're just saying ignore the effects, because in the long run it will be okay. That goes against the grain of the regulations and the way this has been this regime is applied up until now, and I think that's why the amendments that are being suggested, you know, particularly the one that Penny and I have been talking about, which is no, just work with the grain of the regulations. There's a derogation process under that. Let's use that rather than create sort of, I don't know, legal fictions by ignoring impacts for a certain amount of time.
There's a couple I'd like to pick out, Richard. One from Kat Linney at United Utilities. Hi, Kat. She says, she makes the point really that I've made. The proposed changes to the bill seem to remove obligations on the planning authority with regard to the planning permission, but the EA is still required to consider
Exactly right.
when determining an environmental permit. So anything that requires a discharge permit would still have to have an HRA, wouldn't it? And we think yes,
Yeah,
we think that's right.
And it seems like Gove hasn't solved a problem here. He's moved a problem, right? So the problem is with housing and development. It's been moved to the squarely onto DEFRA now, and to the water companies and the EA, and this will be a difficult time for the EA to navigate that.
And David from G Fry says, will you be mentioning the Gove desire for larger developers to contribute to the nutrient mitigation fund as a quid pro quo for the LERB change? This is a significant elephant in the room for quite a few reasons, I'm sure it is. I mean, I personally don't understand why the nutrient mitigation fund, Richard talked about it needing to evolve. Well, it clearly does need to evolve, because if the LERB amendments go through, we don't need a mitigation fund. I mean, so it sounds like all of this is up for grabs. I'm not surprised to hear he's asking from larger developers,
but you see, that's why if instead you did go down derogations and then had a strategic approach for compensation, well, that's what it could evolve into. That's what the nutrient mitigation,
well, that's
then
right,
people contribute their payments into that, and you're doing that in compliance with existing, the regulations as they currently are, but also existing case law, and it would fit. And that's something that the government's already thinking about in the energy bill for the offshore environment, for offshore wind farms. That sort of approach.
It would still effectively be putting the massive responsibility on the developers, when really, if we're honest, it's the discharges from wastewater treatment plants that's the big problem, and diffuse pollution, of course, as well, from farming. So I can see why people like David would be resistant to that. What else?
Nick,
is there any reason to believe the Welsh government will take a similar approach? I think in general the Welsh government like to do exactly the opposite to the English government, don't they? So
well, they're kind of developing their own approach, which it's been explained to me a couple of times by people working on this, and I don't fully understand how it's how that operates. But they're clearly but they're going to this sort of catchment approach for water companies, sort of a catchment approach, and that you can see that coming through in the LERB bill. The proposed amendments to the LERB bill having a catchment approach as well. So, maybe there's a bit of learning from one another, how different jurisdictions are approaching this.
Just conscious of time, you probably got time for one more question.
Okay, well, that's good, because there is just one more from Estelle. What's your view on the impact of the LERB proposals on the growing market in nature and carbon offsets? Plainly, there is a direct impact on the nutrient neutrality market, but I'm hearing the decision has caused jitters in other markets.
Oh, absolutely. I mean, if you're trying to develop, if the government said in the spring we want to be a leader in natural capital markets, they made publications on that. They want to be a green finance hub, and then the moment this gets too difficult, they pull the plug on it, and you kill part of that market. That's going to send all sorts of jitters through the natural capital market for sure. Investors would be concerned about that, and I think if the government wants to rely on free market solutions to problems, and there are reasons why that's beneficial, because it's a more efficient way of delivering things, it needs to think carefully about interventions like this.
Yeah. Okay, great. Well, I think we've come to the end then. It's 12 o'clock, of course. Thank you everyone for joining us. We hope you found it informative. I think our colleague Tom will be uploading this onto YouTube in case you do want to listen to it again or tell your friends and family about it. But otherwise, thank you very much. Please come back to us with any questions on the internet, on LinkedIn, or call us, whatever. We're happy to hear from you and answer questions generally. Thank you.